Can a police officer in Canada actually force you to empty your pockets just by threatening to throw you in jail? You're standing there, an officer says, "Empty your pockets or you're going to jail," and your heart starts pounding. Is that threat even legal? Do you have to do what they say? Here's the honest answer. It depends. And most people get this completely wrong. They hear the word jail, they panic, and they start pulling everything out of their pockets before they even stop to think. That single reaction, done out of fear, done to cooperate, can turn a 5-minute street stop into a criminal charge that follows you for years. It can hand the police the exact evidence they needed and couldn't legally get on their own. So in this video, I'm going to walk you through two very real situations, because the answer is completely different depending on which one you're in. First, you're stopped on the street, you have not been arrested, and an officer tells you to empty your pockets. Second, you've actually been arrested, and now the search rules flip almost entirely. In both situations, I'm going to give you the exact words to say, word for word, so you don't have to think under pressure, and I'm going to tell you exactly which section of the charter actually protects you and why. No filler, no fear-mongering, just what the law really says. Let's get into it. Picture this. You're walking home late one evening. Maybe you're the only person on the street. A patrol car slows down. An officer gets out, asks you a couple of questions. Where are you coming from? Where are you headed? And then comes the line, empty your pockets or you're going to jail. In that moment, most people's brains do one of two things. Either they freeze or they immediately start emptying their pockets to show they've got nothing to hide. And I understand the instinct completely. When someone in a uniform threatens you with jail, your body wants to make the threat go away as fast as possible. But this is exactly the moment where knowing your rights matters most. Here is a common misconception. A lot of people believe that if a police officer tells you to do something, you are legally required to do it, that a command from a cop automatically carries the full force of law behind it, and refusing is a crime. That is simply not how it works in Canada. An officer can ask you to do all kinds of things, but an officer asked and the law requires are two very different things, and the gap between them is where your rights live. Let's start with the foundation. The most important protection here is Section 8 of the Canadian Charter of Rights and Freedoms. Section 8 says, and I'm quoting the actual wording, "Everyone has the right to be secure against unreasonable search or seizure." That's it. Short, but powerful. And the Supreme Court of Canada has spelled out what unreasonable means. In a case called R v Collins, the court laid out a test. A search is only reasonable if it is authorized by law, if the law that authorizes it is itself reasonable, and if the search is carried out in a reasonable manner. All three have to be true. So notice what the real question is. It is never, did the officer tell me to? The real question is always, does the law actually give this officer the power to search me, right here, right now? That reframe is everything. Once you stop asking whether the cop sounded serious, and you start asking whether there's a legal power behind the words, you're thinking like a lawyer instead of reacting like a frightened person. Now, when you are simply stopped on the street and you have not been arrested, do the police have a general power to reach into your pockets and go through them looking for evidence? No. There is no general power in Canadian law that lets an officer search a person just because they stop them and don't like the look of the situation. There is one limited power you need to understand, and I want to explain it carefully because people constantly get it wrong in both directions. It comes from a Supreme Court of Canada case called R v Mann, decided in 2004. In that case, the court recognized that when police are detaining someone for investigation, an officer can do a protective pat-down search, but only under specific conditions. The officer has to have reasonable grounds to believe that their own safety, or someone else's safety, is at risk. And here is the part almost everyone misses. That pat-down is strictly for weapons and officer safety. It is not a license to empty your pockets and paw through everything you're carrying to hunt for evidence. The court in Mann was crystal clear about this limit. A protective search is about making sure you're not holding a weapon that could hurt someone. The moment that search stops being about safety and turns into a fishing expedition for evidence, it crosses the line and becomes an unlawful search. And there's more. The courts have also said there is no general power to search your bag or go rummaging through your belongings just because you've been detained. The safety pat-down is a narrow thing, not a blank check. So think about what empty your pockets or go to jail really is in this scenario. Telling you to pull everything out so the officer can inspect it is not a protective pat-down for weapons. It's a search for evidence. And the threat of jail attached to it is not by itself a legal power. It's pressure. It's a tactic. It works because people don't know that it's not backed by an actual search authority in that moment. I see people make this mistake all the time. They think that by emptying their pockets, they're being cooperative. They're being the good guy, and it'll all go smoother. But here's the trap. When you voluntarily empty your pockets, pockets, or you voluntarily hand things over, you may be treated as having consented to the search, and consent is powerful. It can completely erase the Section 8 protection you would otherwise have had. Think about that. If the officer had no legal power to search you, but you emptied your pockets anyway because you were scared, you may have just handed away the very right that would have protected you. You did the search for them. You can give away your charter protection without ever realizing you did it, just by trying to be polite under pressure. So what do you actually do? You stay calm. You keep your hands visible so nobody thinks you're reaching for anything. You don't get aggressive, you don't lecture, you don't argue the law on the sidewalk. And you say this, word for word. Officer, am I being detained or am I free to go? I don't consent to any searches, and I'd like to speak to a lawyer. Let me break down why every single piece of that sentence is doing important work. Am I being detained or am I free to go? This forces the situation to become clear, and clarity is your friend. This ties directly to Section 9 of the Charter, which says, everyone has the right not to be arbitrarily detained or imprisoned. If the officer says you're free to go, then you are free to calmly, quietly walk away. You don't have to keep answering questions, and you certainly don't have to empty anything. If the officer says you are being detained, then now you know your legal status has changed, and you know to be even more careful about what you say and do. I don't consent to any searches. This is the phrase that protects your Section 8 rights. It makes absolutely sure that whatever happens next, nobody can later claim you agreed to the search. You are on the record refusing consent. I'd like to speak to a lawyer. This signals that you understand the process and you're not going to be talked into anything. Now, I want to give you one very honest and important caveat, because I never want you walking away from this video with a false sense of what these words do. Saying, I don't consent, does not physically stop an officer who has already decided they're going to search you. It is not a magic force field. What it does, and this is huge, is preserve your rights for later. If that search was not actually authorized by law, the fact that you clearly, calmly refused consent becomes enormously important down the road. A lawyer can later challenge that search in court, and under Section 24(2) of the Charter, evidence obtained through an unreasonable search can be excluded from your case. But if you consented, that whole argument may disappear. So understand your real job in that moment. Your job on the street is not to win the legal argument then and there. You will not out-argue an officer on the sidewalk, and trying to will only escalate things. Your job is to stay calm, keep your hands visible, refuse consent clearly, never physically resist, and protect your position so that a lawyer can fight it properly later, on paper, in front of a judge, where the real fight actually happens. One more practical note before we move on. I mentioned that there is no general law forcing you to identify yourself in most street situations in Canada. That's broadly true. In most ordinary circumstances, if you're just walking down the street and haven't been lawfully detained or arrested, you're generally not required to produce ID or answer questions. But I want to be careful and honest here. This is an area where the specifics can vary by province and by the exact situation. For example, the rules are different when you're driving a vehicle, where you generally do have to produce your license and documents. So don't treat "I never have to identify myself" as an absolute rule that applies everywhere in every situation. If you're unsure, that's a question for a lawyer who knows the rules in your specific province. Now let's change one single fact and watch how much it changes everything. This time, you have been placed under arrest. Maybe the officer has clearly said the words, "You're under arrest." Maybe you've been handcuffed and told you're being arrested for a specific offense. And now, in that situation, the officer tells you to empty your pockets or simply start searching you. Here is where a lot of people flip straight into the opposite mistake, and it's just as damaging as the first one. They've watched a video like this, they've learned the phrase, "I don't consent," and now they think they can keep refusing everything, even after they've been arrested. They think Section 8 means the police can never search them without their permission. That is wrong, and it's important that you really understand the difference, because getting this wrong after an arrest can create a brand new criminal charge on top of whatever you were arrested for. Once you have been lawfully placed under arrest, the police in Canada have a well-established power called search incident to arrest. This is a long-recognized common law power, and it is real. It allows police to search you when you've been arrested, for specific and legitimate purposes, to make sure you aren't carrying a weapon that could hurt them or you, to protect the safety of everyone involved, to prevent you from destroying or hiding evidence, and to discover evidence connected to the offense you were arrested for. So once there's a lawful arrest, a search of your person, including your pockets, can absolutely be lawful. This is not a gray area, and this is not the moment to stand on the phrase from Situation 1. So the strategy in this situation is completely different. This is not the time to physically resist. This is not the time to try to play lawyer and block the search. If you're under arrest and the police are searching you incident to that arrest, physically fighting that search can hand you an entirely separate charge, like resisting arrest or obstructing a peace officer. And now you've made your situation dramatically worse over something a lawyer might have been able to handle for free later. Here's the mindset shift. After a lawful arrest, what you're protecting is no longer your pockets. What you're protecting is your mouth and your access to a lawyer. Those are the things that actually matter now, and those are the things that are still fully within your control. This is where Section 10 of the Charter becomes the most important tool you have. Section 10b says that on arrest or detention, everyone has the right to retain and instruct counsel without delay and to be informed of that right. Read that again. Without delay. The Supreme Court of Canada has said this means the police must give you a reasonable opportunity to actually contact a lawyer, and in most circumstances, they must hold off on questioning you until you've had that chance to get legal advice. That is a genuine, enforceable obligation on the police, not a suggestion. And alongside that, you have the right to silence. Your protection against being compelled to incriminate yourself is rooted in Section 7 of the Charter, which protects your life, liberty, and security of the person, and the principles of fundamental justice. And the right to silence is one of those principles the Supreme Court has recognized. In plain English, you do not have to explain yourself, you do not have to answer their questions, and you do not have to talk your way out of it. In fact, trying to talk your way out of it is one of the most common ways people dig themselves deeper. So if you've been arrested and they're searching you, here is exactly what to say, word for word. I'm not resisting. I'm going to remain silent, and I want to speak to a lawyer now. Let me break down what that one sentence accomplishes, because it's doing three critical jobs at the same time. I'm not resisting. This puts it clearly on the record, and very often on the officer's body camera, that you are complying and not fighting. That single phrase can be the difference between walking away with only the original issue versus catching an extra resisting or obstruction charge. You're documenting your own cooperation in real time. I'm going to remain silent. This invokes your protection against saying something that gets turned into evidence against you. Anything you say during and after an arrest can and will be used, so you're closing that door on purpose. I want to speak to a lawyer now. This triggers your Section 10b right, and it puts a legal obligation on the police to give you that opportunity. The word now matters. You're not asking politely if maybe someday you could chat with a lawyer. You're invoking a right that they are required to respect without delay. And then, this is genuinely the hardest part for most people. You actually stay quiet. I see people make this mistake all the time. They say the magic words. They invoke their right to a lawyer beautifully, and then 30 seconds later, they can't stand the silence. So they start explaining, justifying, arguing. But officer, let me just tell you what really happened. And in doing that, they throw away the exact protection they just claimed. Invoking your right to silence only works if you then actually stay silent. Say the sentence, and then let your lawyer do the talking. The silence will feel uncomfortable and awkward. Let it be awkward. Awkward silence has never once been used as evidence against anyone. Explanations have ended countless people in jail. Now, one more honest and important point, because I always want to level with you. Whether the arrest itself was actually lawful, and whether a particular search went beyond what the law allows, can get genuinely complicated. Not every arrest is a lawful arrest, and not every search incident to arrest stays within its proper limits. But, and this is the key, that is not a fight you have on the sidewalk in handcuffs. You will not resolve it there, and trying to will only make things worse. If you believe you were searched unlawfully or arrested without proper grounds, that is a conversation for a lawyer afterward. Someone who can look at exactly what happened, examine the specific facts, and challenge it properly in court where it counts. Some of these details also vary by province and by the precise circumstances, which is one more reason the courtroom, with a lawyer, is the right place for that battle, not the street. Alright, let's pull all of this together into three simple points you can actually hold on to when it counts. Because the whole reason we did this is so you're not standing there frozen and afraid. Number 1. If you are not under arrest, the police do not have a general power to make you empty your pockets. And empty your pockets or go to jail is pressure. It is not automatically a legal order. The only street-level search power is the limited protective pat-down from RV Man, and that is strictly about safety and weapons, not a search for evidence, and it doesn't extend to rummaging through your bags. Your line in this situation is, "Officer, am I being detained, or am I free to go? I don't consent to any searches and I'd like to speak to a lawyer." Don't hand away your rights by cooperating out of fear. Number 2. Once you have been lawfully arrested, the rules change, and search incident to arrest is a real established power, so this is not the time to physically resist. Instead, protect what still matters, your words and your lawyer. Your line here is, "I'm not resisting, I'm going to remain silent, and I want to speak to a lawyer now." Then actually stay silent and let your lawyer handle the rest. Number 3. Remember your 3 anchors, because these are the sections that carry you through both situations. Section 8 protects you against unreasonable search or seizure. Section 9 protects you against arbitrary detention. And Section 10B gives you the right to a lawyer without delay. Across both scenarios, the playbook is the same underneath. Stay calm, keep your hands visible, don't consent to searches, never physically resist, say as little as possible, and let a qualified lawyer sort out whether anything crossed the line. Save this video so you've got both of these exact phrases the moment you ever need them, because you will not want to be inventing the words under pressure, and I'll see you in the next one.